Thanks.
All right, and I think we're going to turn the meeting over to Judge Rowan. This is item number 2, oral argument on non-adopted proposed decision. Dr. Onuba.
Thank you, Ms. Lawson. Before we get going, I just want to remind everyone that we have a court reporter on the line. She's going to be taking down everything that is said. So we need to make sure that she can hear. So whoever is speaking, I'll ask you to speak loudly and clearly enough so that she can hear you. And also ask, if you are not speaking, to keep yourself muted. That cuts down on background noise and helps the meeting flow a little bit better. That said, Jody, thank you for being here. Let's go on the record.
On the record.
You're on the record before the Medical Board of California and the matter of the petition. My apologies. This is the oral argument after the non-adopted petition for reinstatement. Respondent is Dr. Boniface Okwudili and Medical Board number 800-2019-055-701. OAH number 2020-100457. Today's date is November 12th. This matter is being held via video conference. This is the date, time, and place set for oral argument in the notice of hearing for oral argument. My name is Heather Rowan.
Cutting out.
Sorry, there's noise behind me. I apologize. My name is Heather Rowan. I'm an administrative law judge with the Office of Administrative Hearings. I've been assigned to preside over this hearing. Prior to going on the record, Ms. Lawson, the chair of panel B, ensured there is a quorum. May take the appearance of counsel for the Attorney General, please.
Good morning, Your Honor and panel members. E.A. Jones III, Supervising Deputy Attorney General, on behalf of the Attorney General.
Thank you. And for respondent.
Good morning, Your Honor. Tracy Green for Mr. Onuba, who's present.
Thank you. The board in this matter has issued an order of non-adoption of a proposed decision by an administrative law judge and has decided to determine the matter itself. The board has invited discussion of whether the proposed order should be modified. The following process and time limits will apply and will be enforced. Respondents' counsel will have 15 minutes to make an opening argument. The Deputy Attorney General will have 15 minutes for a response. The respondent will then have 5 minutes for closing argument. And the Deputy Attorney General will have 5 minutes for closing. The time limits will be enforced. I will tell you that you have 1 minute remaining.
Judge, I'm not understanding you. Maybe if you can speak closer to your microphone or something.
Yeah, there's my neighbors have noise going on, but it should be going for a couple of minutes. I apologize. Can you hear me?
You're cutting it out.
Okay. The argument will be based on the existing record and will not exceed the scope of the record of the admitted evidence. No new evidence will be taken today. The panel members may ask questions of the parties to clarify arguments, but may not ask questions of other witnesses.
I'm not hearing anything.
Can't hear anything clearly.
You are hearing everything?
I cannot hear most of the stuff clearly.
I'm looking out my window to see if Can you hear me if I speak louder? Can you hear me if I don't use the headphones?
Yeah, Judge Rowan,
I suggest taking the headphones off.
it sounds like the mic wasn't working on your headphones, so.
Okay. Sorry, this is bad timing for them. Jody, can you tell me what you heard so I can go back?
I have the panel member questions of the parties to clarify, and then that was it.
Okay, so let's go back on the record. The panel members may ask questions to clarify, but may not ask questions that elicit new evidence. At the end of the oral arguments by counsel, the administrative law judge shall offer the respondent's position an opportunity to address the panel regarding the penalty. If the respondent elects to address the panel, I will place the respondent under oath. After the oral argument, the board will go into closed session to deliberate. The parties will not receive a decision today, but will be receiving it sometime in the future. And to reiterate, I will unmute myself and give you a 1-minute warning time. Ms. Green, are you ready to proceed?
Yes, I am, Your Honor.
Okay, your 15 minutes starts now.
This is a case where the petition that was submitted by the physician or the former physician was sufficient to establish that he's sufficiently rehabilitated. In addition, the evidence at the hearing was sufficient to establish that he was rehabilitated. What I see as being one of the key issues that occurred here at the hearing was that it was as if the underlying case was being re-argued. And we've got a situation where the complainant's argument is that because Mr. Onuba did not sufficiently acknowledge some of the facts in that decision revoking his license, that was sufficient grounds to not reinstate him. And that is in spite of the fact that he's previously had 29 years of practice. There was no criminal conviction. His conduct since the decision has been exemplary. He's not committed any other type of misconduct, has really not been in the medical field. He's done other things, such as being a caretaker for his autistic son and doing other work. But it has been 6 years since his license was revoked. It's been 10 years since the acts that occurred that led to the revocation. Now, I think we all know, and certainly Mr. Onuba knows, that the fact that his prescriptions were used by others, to write prescriptions for narcotics was serious. And the records show that he was not involved. He didn't have a criminal conviction. That part was cleared. He cooperated with the government. Now we just have the situation of his inability at the hearing to properly follow some of the questioning. And since he was representing himself, and distinguish between what happened back then, what happened more than 10 years ago, and what has he been doing now. So he gets licensed in 1993. He practices successfully for years. The accusation and the charges that came up, those were the only ones that were ever filed by him. Now, certainly he understands that he has the burden. And I do think that at the hearing, it appeared to get very testy and a little bit personal, particularly during these times. I think Mr. Onuba certainly understands that everyone is doing the best that they can to make decisions on what's best for the state of California. He did make some statements where he referred to racism or particular motivations, but that's not why he believes he lost his license to begin with. I think this was a hearing that went way off track, and whether it's also his, and if you look at, when you read the transcript, it's replete with either the court reporter or the judge not being able to understand his accent. So there were some cultural issues there. So I think if we just look at the regulations, California Code of Regulation, Title 16, 1360.2, let's look at the acts that occurred. They were serious. They didn't result in a crime. Luckily, no patients were hurt. Unfortunately, by him being careless and having prescriptions in offices that others used, it could have led to someone else's harm, but he didn't intend to do it. He didn't have any other issues or any other crimes or any other conduct. Obviously, there was a little bit of issue with some of his documentation in the charts. Now, when you have a situation where on the records, for example, he did his best now to explain what was happening 10 years prior. But one of the things that when you go in for a petition for revocation, the purpose is not to go back and relitigate it. It's deemed admitted. The decision's already been found. And what I saw at the hearing was that during the questioning, the focus was to relitigate that and try to see if Mr. Onuba was going to be defensive, things in the right way. He certainly took responsibility over and over. And then he would make a statement about some of his dissatisfaction with either his legal representation or the way the interview was handled. But that's not someone who doesn't understand the severity of what happened. When you look at the facts of this case and the original accusation, this is the type of case where it does not merit a denial in total. Dr. Onuba has a lot to offer the state of California. He's a neurologist. He has good training. He had practiced for years without any issue. And certainly the state of California and its citizens would be well protected if he were subject to the standard terms and conditions of probation for 3 years or whatever the board would deem appropriate. Unfortunately, we can see that Mr. Onuba had some financial issues where he didn't have counsel present. And although that is not a factor to be considered under the regulations, I think it helps explain why that hearing became a focus on the past. I think that it's certainly, there were no questions about guidelines or neurology. The judge, the administrative law judge, and the deputy attorney general did not ask him anything about his skills. He certainly had testified that he had tried to keep up on his knowledge. He described other things that he had been doing. And if you look at the original petition plus his statements that really relate to what he has been doing, that is sufficient to allow him to be reinstated on proper terms and conditions. There's no, it's very unfortunate that when someone like Mr. Onuba has shame and is very regretful of how the whole process happened and how his life has been difficult the past 10 years since he hasn't had a license. So much of that seeped into it. But if we focus on the nature and severity of those original acts, the amount of time that passed, 10 years since those occurred, 6 years since his license was revoked. And there are no other issues with respect to his license. I think he established that although it was a bitter pill for him to swallow, that he learned a lot from it and that he would have good judgment. He testified as to his future plans and that he did not want to work for small clinics, that he wanted to focus more on research. And to claim that he is not honest or trustworthy, as complainants suggest, because he disagrees with the way his process, the procedural process happened to him, is really not fair. It's almost as if during the hearing it was just taking a stick and poking it at Mr. Onuba, knowing that this was a sensitive issue. And it looked like the administrative law judge was trying to give him an opportunity to explain some of these issues, but it appeared to be there were miscommunications. And then he thought he had to explain what happened in the past. There's not I'm just going to look at, one of the things that I do see with Dr. Onuba is that when you see what he's been doing since the time that he'd lost his license back 6 years ago, he's been working for Los Angeles County Department of Public Services, where he had to pass a background. He'd also worked at Universal Management Solutions, and he's also been keeping up his educational activities, seminars, CME, government publications, doing volunteer work at various clinics as a medical assistant. Those are the facts that are set forth in his petition for penalty relief. And it is, I will say that it's, Mr. Onuba does have a heavy accent. And I certainly know that the board is used to dealing with people of all cultural backgrounds and the like, but I would say that this was a factor that I was not at the hearing, but that I could read in the transcript. And if the court were not inclined, or if the board were not inclined to reinstate with terms and conditions, I think it would at least be appropriate to send it back for further hearing on the limited issue of post-revocation efforts, and focus on that rather than what focused, on the hearing. He has no substance abuse issues. He had never had any malpractice cases. He'd never lost his privileges. This was not a dangerous doctor. This was a doctor who did put himself in a situation where his prescription pads were used, But when you look at the nature of the case and the severity of the punishment, it appears to be an abuse of discretion to not allow him an opportunity to be reinstated under terms and conditions where he can prove that he would be safe to practice and that he has, adequate protocols in place, whether it's a monitor or no solo practice. This is his career, and I would submit that the board focus on the rehabilitation evidence, the nature of the acts and severity, rather.
Ms. Green, you have 1 minute.
Okay, focus on that rather than on the go back and forth about what happened in the prior case. The rules are clear. The acts that happened previously do not need to be relitigated. They are only used to show the acts and severity. And in this case, those acts and severity are ones that should allow a reinstatement in this case. Thank you.
Thank you, Ms. Green. Mr. Jones?
Thank you.
Your 15 minutes starts now.
Very good. I'd like first of all to maybe go back and review what exactly transpired in terms of the hearing and the background case. Going back in time, we recall that prior to the decision to revoke the petitioner, the board had discovered and he had admitted that he had pre-signed prescriptions and left them blank ones with no patient names on them at one or more clinics. That obviously is a serious matter leading to potential unlicensed practice of medicine, as well as to aiding and abetting or promoting diversion of narcotics. Serious matters indeed. The board, in its decision in revoking the petitioner, indicated that he demonstrated disregard for patient health and safety and professed no remorse for his action, which precluded a finding of rehabilitation or the possibility of working toward rehabilitation. So that was in the October 2015 decision. Now we come forward to the hearing on the petition for reinstatement, and at the end of the day, the ALJ came to similar conclusions that the board had come to in the decision to revoke, indicating the petitioner had demonstrated an absolute lack of remorse for the actions that led to the revocation of his license, and taking no responsibility for leaving pre-signed prescriptions at the clinics where he worked. Now, during the course of that hearing, as counsel for petitioner pointed out, there was a particular focus by petitioner on the prior case. And he made statements such as that the DAG made everything up because he knows that in this society, everybody will leave anything against a Nigerian. He made other similar remarks such as, this nonsense that I was there writing prescriptions and giving prescriptions and just made up by the DAG. The ALJ attempted during the course of the hearing to redirect the petitioner, saying that she needed to hear not everything that happened before your license was revoked, but everything since then. And petitioner did follow that cue to some degree and discussed his impoverished African background, childhood, his religious faith. He indicated that he gives a certain large amount of his income to charities. The ALJ later noted that she heard what he had to say, that he had taught for a while in Beverly Hills, but couldn't maintain that schedule because he had to care for his son. The ALJ indicated that she knew that he had engaged in activities at the Westside Regional Center and that he had interacted with clients and their mothers in those settings, and that he had studied very hard to continue his training. Now, so the petitioner did testify to certain rehabilitative efforts, even while contesting the revocation decision. So on the face of things, a petitioner who focused in the hearing on attacking the board's decision to revoke him, you have the ALJ's statement that the petitioner did not take responsibility for the conduct that led to his revocation. The case law indicates that the board may take into account the petitioner's attitude toward the offense. The board can consider evidence of a change of attitude from that which existed at the time of the conduct. Application of these concepts would suggest the board deny reinstatement. Let me suggest, though, that there are other considerations to be weighed here. In the legal profession, it is said that an attorney who represents himself as a fool for a client. The same may be said for a doctor who represents himself, as petitioner did in this hearing. His focus on contesting the revocation decision may have resulted from an imperfect understanding of the administrative process and the finality of the findings in the underlying case, as well as from cultural differences. Importantly, in his written petition, he did address some important issues. He indicated that, regrettably, the revocation was based on a gross misunderstanding of his truthful but not clearly defined and unfocused answers. Despite that statement, he did state that with determined rehabilitative intent through continuing education courses on controlled substances and controlled substance use, abuse, and medical ethics, he bolstered and fortified his practical knowledge of controlled substance clinical use and optimal prescription practices, such that his medical practice will now meet expectations and standards of the medical regulators. He stated that he has learned his lesson from his mistakes, and if reinstated, will take the necessary steps to ensure he never repeats the negligent or problematic practices in the future. The board, as the ALJ indicated previously, traditionally gives the petitioner an opportunity to speak to the board at the close of argument. I recommend that you panel members pay close attention to petitioner's statement and, if necessary, solicit from him a pledge before the board and before the public that if reinstated, he will abide by the laws and regulations that govern the practice of medicine in California and will live up to the highest standards of the medical profession. If the board determines to reinstate petitioner, it should place him on a probation with a condition precedent to complete a clinical competency training program, such as the PACE program in San Diego. Because the board does not rely on a physician's self-certification of competency when the physician has not practiced medicine in 6 years. He should also be required to complete a professionalism program to assure the board that he is aware of the ethical standards required of physicians in California. In addition, record keeping and prescribing courses should be required to ensure that his knowledge base in those areas is up to standard. Thank you for this opportunity to provide an argument on behalf of the Attorney General.
Thank you, Mr. Jones. Ms. Green, you have 5 minutes to respond and close.
Thank you. And I understand some of the suggestions that were made by complainant's counsel. I would think that a PACE program would not be necessary, given that there was no indication of incompetency or any other problem. And this is what happens when his last petition for reinstatement was denied, that there is time that passes. However, if educational classes could be added as well as a monitor, or perhaps even an evaluation that would be done initially before going to the PACE program. I think there's some other alternatives that the board has here. This is the type of case where we want the public to be protected. We know that, the fact that someone is representing himself and is a fool for a lawyer, there are equities, there's justice, there are right ways to handle it when someone does not express himself well when he's trying to defend himself. And his own monetary issues obviously had a role in that. So we trust that the board would look at the facts, look at what really happened with respect to that underlying case, consider the time that's spent, and come up with a reasonable probation terms that fit the facts of this case. This doctor was not a pill pusher. He was not someone that was prescribing pain pills to someone who didn't need it. There was no evidence of any incompetency or negligence on his part other than leaving these pre-signed prescriptions and leaving prescription pads. Administrative boards have a lot of discretion, and that discretion should also look into the type of hearing that a physician or licensed professional is able to present. And it's unfortunate it wasn't better organized, and it's unfortunate that he got a little bit defensive, but I would ask that the board put themselves in Mr. Onuba's shoes and understand that it's a difficult place to be, and he is extraordinarily remorseful, wants nothing more to try to get back and practice neurology again, especially in the research field. And with that, I submit.
Thank you, Ms. Green. Mr. Jones, do you have a close?
Thank you, Your Honor. A few words, yes. I want to point out that the board's standard terms require that if a physician is out of practice for more than 18 months, that he or she must complete a clinical competency assessment program. And so in this case, we're speaking of a much longer term of non-practice, 6 years. So I think applying the normal standards to this case, a competency assessment is really called for in order to protect the public, to ensure that Mr. Onuba does have the requisite skills to practice medicine in the state. I would point out further that part of the PACE program or part of the competency programs that are available to him, they do include an assessment, and they may, as a consequence of that assessment, limit the need for further study or training. Thank you.
Thank you, Mr. Jones. Ms. Green, did your client wish to address the board this morning?
No, he does not, Your Honor.
Okay, thank you.
But he is willing, if there are any questions from the panel members, then he is open to answer.
Okay, then let's go to the panel. Ms. Lawson, do you have questions?
I do not.
Dr. Thorpe?
Sorry, it took me a minute to get unmuted. I think, yeah, it's concerning to me. It seems to me that the issue that created the lack of reinstatement was the concern about absolute lack of remorse, and then the relitigation of the initial issue. And so I would just ask Dr. Onuba, I mean, I think the board is, wants to be able to reinstate a person who could be a benefit to society, but we also need to know that you clearly understand the problem and that you're willing to actually say that you recognize that. Is that something that you can do?
Mr. Nuba, if you're going to address the board, I'd like to swear you in and take your statements under oath. Will you raise your right hand, please?
I do. I mean, I have.
Do you solemnly swear or affirm under penalty of perjury that the testimony you give today will be the truth, the whole truth, and nothing but the truth?
I do.
All right, thank you. Go ahead and respond.
My response is that when I went to the hearing, I was just prepared to just tell them that I was sorry about all that happened, and I was going to tell them my plan to make sure it doesn't happen again. And then I had spoken with the investigator last year, who actually advised me also that it was for me to go and present my rehabilitation and every other thing that I intend to do, so I can be the board.
I didn't hear the last words.
So that the board can.
Mr. Nuba, can you go back and repeat yourself? Jody, I'm not sure what cut off.
Okay, it is, last year he actually advised me also that it was for me to go and present my rehabilitation and that's it.
Okay, I'll go from there. So when I went to the hearing on June, this past June, and the deputy DA had to present first, I was taken aback because in her presentation, she went to what happened in trying to go against my reinstatement. And I believe that sort of pushed me off track because I didn't think the hearing was for me to go back into what happened. Maybe I'm not the greatest at controlling my emotions, but I know that pushed me off track. I didn't go in and with the intention of being not being apologetic enough or being I maintain today that what I wrote in my declaration, that I will never, first, that I'm sorry for all that happened, and two, it will never happen again. That is what I said, and I was saying it even though I'm not kneeling down, on bended knees. I was thrown off guard by the presentation of the deputy DA because and I'm sorry about that again. So
he gapped for me. There's a gap in his testimony.
Okay. I think it was right before he said, "I'm sorry." Did you, Mr. Nuba, can you repeat yourself?
And I said that I did not intend to go into the hearing to really litigate what happened or to be in a position that looks as if I was not apologetic. It's just that when she raised so many issues about the hearing in her presentation, it sort of pushed me away from what I was going to say. And but what I'm saying right now, without mincing words, is that for that, the way I sounded in the hearing, I'm sorry. My intent had always been, and still is, to let the board know that I was sorry for everything that happened, that it will not happen again. I've done that. I've done all kinds of rehab and all kinds of study and all kinds of the regulations to make sure that if I start practicing again, never, yeah, I will never find myself in a position where I will be subject to any kind of any problems. I don't know. I think I should stop now.
Okay. Thank you. Dr. Thorpe, do you have additional questions?
No, I think that actually answers my question. So I appreciate the opportunity. Thank you, Judge.
Okay. Mr. Gonadev?
No, Judge. Thank you.
Dr. Kraus?
No questions.
Dr. Mahmood?
Yes, he actually answered my question. The only other thing is that there should not be any hesitation on the PACE program. I think that is absolutely necessary if we consider reinstatement. That program is going to be absolutely necessary. I know his counsel has shown some hesitation on that, but I think we just want to make sure that that is definitely needed. No other question.
Did you have a question, Dr. Mahmood?
Yeah, my question to Dr. Mobe is that would he have any hesitation on any of those conditions board will put on if board decides to reinstate it?
It's up to the board. What the board wants is what I'll do. If I have any problems, the only problem I've had in the past has always been my son's. But I'll abide by the board's decisions. I'll abide by the board's decisions. Did you hear me?
Yes, yes, yes.
Out here.
Okay. Thank you. No more question from me.
Thank you. Ms. Pines?
Yes, I have a question. So, Mr. Anuba, what have you been doing in the last 6 years to stay on top of your specialty?
What I've done first is I have, even though I submitted 70 hours as what I did in 2 years, but I believe I've done over 300 hours because I love science and research. So in terms of studying, I'm on top. But also, what I've done for many doctors, as I do even now, is I assist them in what they do, like at the clinics. When they see patients, like Dr. Edelman is a neurologist, so I help him with all his work and then do the transcription for him. A lot of the doctors, about 20-something of them generally. So everything they do in medicine, in neurology, in sometimes in psychiatry, like one psychiatrist. I've been in medicine, and also because my son has autism and with comorbidities of psychosis. They're not sure if it's schizophrenia, but it probably is. And also being that we have programs with the West Regional Center that I've been going. So a lot of times, because of my knowledge, and I'm good with all the people. So besides taking care of my son, I also find myself helping everybody who comes. Like a lot of mostly women whose children have the same disabilities when we go to the programs. So I have to break things down for them, and they can always call me anytime when they see their doctors. Sometimes they don't understand scientific terms or what they need to do. Then I'll have to break it down for them. So basically, I've been in medicine, and I've also been working on what I call assistive programs to try to help. Because I'm a research person. When I left Nigeria and came here, the initial plan was just for me to come in and get a Nobel Prize. That was the thing, because I was very young and they would say I was very smart. So I've been working on those two. I have a lot of things I've been doing that I hope that once I get back, I'll go back to UCLA to see if they'll let me help start a quantum neurology biology program. because I love those things and I read them to the highest levels. I've studied, I probably know as much of quantum mechanics as any quantum person. So, and then biology. So I'm really into all those things. So whatever level any person wants to know. So I wouldn't be, I don't need, somebody does not have to believe me. If I go to any programs, they will know. Because that's the only thing I may not have money, like my father used to say. You may not be maybe poor, but nobody better work harder than you do to know as much as you need to do to help your fellow man. So that is what I've done. I don't go out. I haven't gone out for coffee in 6 years. I sit down and study and help my son and study. I'm more. I study every Lancet, because I read so many publications on this COVID program. I've read so much about it that I know I can contribute, because everybody knows me as a physician scientist since I was in medical school. I like to take that as the primary title as a physician scientist, even before being a neurologist or anything else. So I have done it, and I don't mind being tested or queried, by anybody about it.
Okay, thank you.
Anything further, Ms. Pines?
No, that's it.
Okay, thank you. Just to be sure, does any panel member have any follow-up? All right, thank you all. Ms. Green, Mr. Jones, thank you for your argument today. There is nothing further. This matter will be submitted. The board will go into closed session to deliberate. The record's closed. We're off the record.
Thank you, Your Honor.
Thank you.
Thank you very much.
Thank you.
Okay.
Jody, before you go, could I get the estimated pages and the ending time, please?
Yes. 30 pages. And I will need the name somebody that Dr. Anuba mentioned that he does transcriptioning for.
Edelman, Edelman, Dr. Edelman.
Okay, thank you.
Anything else, Jody?
One more thing. Mr. Jones said something about the ALJ in activities at, and what I heard was West Nile Regional Center. What regional center was?
Western Regional Center.
West Regional Center. West Regional Center.
Okay, thank you. West. That's all that I have.
Okay, great. Thank you. All right. Ms. Lawson, we'll turn it back to you. Jody, thanks for your help on your patients today.
Thank you. So I'm going to get off.
I think we're through, so you are free to go. Yes.
Okay. Thank you very much. Bye-bye.
Okay, thank you, everyone, and stay safe. All right.
Thank you. Bye.
Thank you. And my understanding is that we have a separate closed session link. Is that correct, Sean or Michelle?
That is correct. You'll be using the separate confidential link for the closed session. So if you can go ahead and leave this session now and go to the new session.
Thank you.
Thank you.
All there. All right, Sean, I still couldn't hear you, so your mic must be off, but I'm going to consider this panel be adjourned and leave.